What is timely? Is it the moment that it happens? Is it I needed to go to the doctor and took a half day off and then decided to tell the employer the next day? What is considered timely? What's the range that you have?
That's a good question, and there's no specific time frame in place. It's sort of a common sense or reasonable standard. I mean, we've had people report injuries way after the fact. You mentioned occupational disease earlier. Oftentimes someone will be developing a problem. Let's say it's carpal tunnel syndrome, which most people have heard about these days. It's a disease that comes on over time, usually from repetitive use of the hands, and you start to develop some numbness or pain or weakness in your hands. And a lot of people aren't sure what's causing it. They wonder if it's arthritis, is it poor circulation, all kinds of things go through their minds. So it's very common with that condition that they don't know what the problem is and don't know that it's work-related until they see a doctor. So in that case, it's extremely logical that they get an exam, maybe even get sent off to a specialist, get tested. And once the specialist determines what the problem is, and if they ask any questions about the work history, they'll then connect that to work, and then the person could report the claim. It also happens that someone, as I said earlier, hurts a knee or a back, and at first they think like anybody else, we're going to shake it off, I'm going to get through this, I need to work, and I'm not looking for anything. And then only months later does it become a problem. In those cases, sometimes best intentions aside, they'll report it after the fact. Hopefully they've got a witness to the event, hopefully they've complained to someone along the way, or mentioned it, even if it wasn't a formal notice of injury. And that's the other thing about notice. A lot of people think, well, I have to put something in writing, or I have to follow a certain procedure, but that's not the case. Workers' comp is satisfied if it's a verbal notice. Sometimes employers will have specific procedures where they'll fill out or have the employee fill out a report of injury type of a form, but the notice requirement does not require a particular type of notice, just that you let the employer know.
You know, it's interesting. We said that there's plenty to cover with workers' compensation, and actually we haven't even gotten into the law itself yet, but rather some of the things that are on the prophylactic side. So while we're at it, if someone has had the presence of mind to call you when they think it may be job-related and they're about to tell their employees, if they broach the subject with you, what do you say to this? I might end up getting laid off because some of my other people are. This is going to make it too easy for them. Or my work performance hasn't been terrific. This may be the perfect opportunity for them to fire me. How do you arm someone who's asking you that question? Well, they're not supposed to be tied together, correct?
Right, true. I mean, theoretically, those two issues are really, those are collateral issues. Whether a person suffers an injury or at work or not is really a separate issue as to whether or not they were a good worker, whether they had good attendance, whether they got along with their co-workers. All of those really are collateral issues, but the practicality is they all play into the situation. I don't think my advice would typically change. Typically, if you have an injury and it's traumatic in nature, typically in Rhode Island, there's a statute that says that you're supposed to report the injury within 30 days, but practically speaking, you want to report it as quickly as possible, regardless of what the circumstances are, regardless if you're on thin ice, maybe because of bad attendance or poor work performance or whatever. The bottom line is you should report that injury as soon as possible. And quite honestly, I would tell the person to report the injury, because once they are covered by the umbrella, so to speak, of the Workers' Compensation Act, there are protections that are afforded to them. For instance, many people are not aware of the fact that you have an injury, you make a recovery. If it's within 1 year, you have a right in most circumstances to demand reinstatement to your former position. Now granted, there are certain exceptions to that rule, but Massachusetts also has a similar statute that if you have an injury and then you want to try to go back to work and for some reason you cannot maintain a job, if it's within 28 days, the insurance company has an obligation to restart your workers' compensation benefits. So what I would tell a person is that even though there might be collateral issues that might cause them to rethink whether or not they should report an injury, it's always best to report it, get covered under the system, because there are protections afforded to those individuals.
Yeah, just to add, it's a case-by-case basis. I think those facts that you're talking about are real-world questions that people, and it's an excellent question, because as Lenny said, there are certain rights, and we like to isolate the Workers' Compensation Act out to them and say, look, you have an injury, you have rights, this is what you should do. But we can't ignore the fact that this person might feel their job, the hold on their job, especially in this economy, is tenuous. So typically we'd ask more questions. I mean, we might spend 15 minutes on the phone with someone before we even book an appointment with them, just to find out, okay, so what kind of injury was this? You know, how long have you been there? What's your job? and then you start getting these more facts out from the person involved. And if it sounds like it's a very minor incident, we might be satisfied to tell them, if we were you, we would report the injury, just put it on record, tell the employer at this point you don't intend to do anything about it unless it gets worse, and hopefully they just take that at face value, and then you continue to work. You can always call us or seek medical attention later if it becomes a more chronic issue. So it is a case-by-case, fact-by-fact situation, and you really have to be sensitive to the person's employment position. But what we like to tell people is, if you're not in a union or don't have an employment contract, you have more job security going on workers' comp than the average person does out there, and that's what the right to reinstatement does. It says to you, as Lenny said, in most circumstances, you have basically a year's protection where you can demand and file a petition with the workers' comp court to try to get your job back if you recover within 1 year. The average person has an illness or something, not job-related. The Family Medical Leave Act will provide them in Rhode Island up to 13 weeks, federally up to 12 weeks of protection every 2 years is all you get. And after that, your job can be gone and there's nothing you can do about it. So workers' comp provides a lot more protection in that regard if you're out on an injury.
Yeah, that's true. I mean, most employees are considered employees at will. As Bob mentioned, unless you're covered by a collective bargaining agreement or union contract, you have very little protection. You're pretty much at the mercy of your employer. So an employer can basically hire and fire at will so long as they're not violating the discriminatory laws for either for age, race, sex, religion, those type of things. But the bottom line is that most people are employees at will, and if an employer wants to get rid of you, they can. So if you do have a legitimate injury, it should be reported because, as we've both stated, there are a lot more protections afforded to an injured individual under the Workers' Compensation Acts in both states.
And you just offered the springboard to my next question. You mentioned that people will call you and you can give them a straightforward answer, perhaps on the phone after 15, 20 minutes. It may be very straightforward. But assuming part of that reason for that lengthier conversation is to help you determine the legitimacy of it. Let's assume right now, for the sake of argument, and there are enough people who are cynical enough to say sometimes these things aren't legitimate, but saying that it is legitimate, what is the process of workers' compensation like to the person who's been injured? Never mind someone has hurt their back and has to deal with doctors. I understand that there are many hassles that that person needs to contend with, which is why they might call a lawyer, maybe not. But what is the process about, so you can help our listeners evaluate whether or not they do it yourself or whether they call someone.
That's a loaded question.
There's lots of info
Sure
in that one.
it
But
is. But the process itself is worth fleshing out.
And it's daunting, it is. Let's talk about Rhode Island first. Len, I'll jump in, and then Lenny, again, knows much more. You can add on and touch Mass. And we both see Rhode Island and Mass clients all the time. And our standard answer for us is that Rhode Island procedure is much friendlier to the employee in most instances than Massachusetts. Rhode Island, since the reforms back in 1990 and 92, provides a pretty quick entry into the court system for someone who's injured. What typical case? Someone's injured their back at work. They call us up and the doctor's taken them out of work. It's related. They've reported it. And they call us because they're not sure what to do next. Well, we bring them in. We get the facts down from them, generally in about a 1 hour meeting and interview. We then spell out the law to them and how but the first thing they want to know before the substance of the law is procedure, and that's one of the things you're getting at. How do I get paid? What happens? Well, Rhode Island law, in the instance of a first-time injury, gives the insurance company a 21-day window in which they must make a decision. Are we going to pay this person and accept full liability for the claim? Are we going to reject the claim and not pay the person? Or are we going to pay them on a temporary, non-prejudicial basis? That's the one many insurance companies choose, that middle one, because what it'll do is it'll give them some control and some time to really look at the claim. The employee starts getting checks. They think everything's okay. In the meantime, the insurance companies bought themselves 3 months to decide what they're going to do with this person, 13 weeks. And if at the end of 13 weeks they think the person's been out too long, they don't like the medical documentation they're getting, they heard something from the employer that turns them against the claim, they can simply shut the person off, and the person now is, oh my God, what happened to me? So what we encourage people to do is come to see an experienced attorney in workers' comp right away, because the 21-day window is all the employer has. After 21 days, if they have not accepted this claim fully, the employee's rights kick in, and at that time a claim can be filed or a petition can be filed at the Rhode Island Workers' Compensation Court. And typically you're in court in front of a judge who has the authority to order benefits paid within 30 days of that filing. So